Hello and welcome to the Study Legal English podcast. I am your host, Louise, and today I'm very grateful to have the one and only Ken Adams on the show. Hi, Ken. How are you doing?
Hello, Louise. It's a great pleasure to be with you again.
Yes, again. We spoke back in 2020, episode 99, where you spoke about your contract language. So we're back here again. So much has changed in that time.
Yes, in the world, certainly. In my life, not a whole lot, but what the heck? For those who are interested in this subject, I'm sure some of the developments will be of modest interest, so I'm happy to talk about them.
Many of the listeners know who the wonderful Ken Adams is, but if you're a new listener and listening to the show and they don't know who you are, then I'm going to just give a quick introduction to who Ken Adams is. So Ken, you are the one.
Please don't pander to my delusions of grandeur.
You're one of, if not the only person who writes systematically on contract language. Ken is the author of this fantastic book, which I'm going to show you on screen. So if those of you who are listening and watching on YouTube, you can see this book, A Manual of Style for Contract Drafting, now in its 5th edition, brand new, hot off the press, 2023.
Radioactive blue.
I like the
color.
Blue, very professional. Yeah. Excellent. So quite a few listeners might have the previous edition, the 4th edition. It's a fantastic book. Especially the 5th edition. I mean, all of the editions are great, but we're going to be talking about some of the changes that have come into play in this new edition. I call this the Bible for contract drafting, and I think I'm not the only person. A lot of people would call it that. It's been relied on by, and it is relied on by many legal professionals as the go-to manual for everything to do with contracts. It's also been referred to by the Delaware Court, if I'm not mistaken.
Various courts.
As an authority on interpreting contract language. Maybe before we go into some of the changes, how do you feel with the new publication, Ken?
Well, on the one hand, 5th edition, perhaps the novelty wears off of new editions, but it has been 6 years. That's a long time. And there's a lot of new stuff. It weighs in at 667 pages, which is quite a lot, particularly since there is no stuffing, no padding. So it's a big book with 70 pages of new materials. And in the preface, I list what is new. And there's a lot, just because 6 years of rooting around it made me think of quite a lot of stuff. Now, it is a finite subject. This is not going to go on forever with new editions up to the 23rd edition or some such. It's a finite topic. I expect there will be a 6th edition at some point, but we are getting close to a thoroughly comprehensive set of guidelines. And I don't think there's some topic that'll suddenly come to mind that will expand everything. It's just I had to limit the scope somehow, and I made it essentially that I will talk about the building blocks of contract language, the words and phrases, rather than entire provisions. The shorthand way of referring to that is to say the book is about how to say clearly and concisely whatever you want to say, rather than dealing with the what you say part, which is a vast ocean of transaction-specific guidance that I wouldn't dream of going into in static print like this. So this is the starting point, how to say clearly and concisely whatever you want to say, with the understanding that there are plenty of substantive surprises. This isn't a matter of, it's a matter of just stylistic stuff or something. No, the words and phrases you use have all sorts of unexpected implications. That's that's my topic, just to make things manageable. And I'm pretty much close to being there. So wrapping it up. So the 5th edition is a worthy successor to the 4th edition, and it pretty much says everything I have to say for now. And there will be fixes, but I'm pleased with where things stand currently.
Good, excellent. Well, congratulations for surviving the writing process of putting it all together.
It, of course, had its challenges. And by the way, I think it's safe to say I am now indeed the only person who does this stuff. It continues to surprise me, but essentially, I think that when the drafting gods asked for volunteers to live in a cave for 20 plus years noodling over this stuff, I was the only volunteer who presented themselves. It requires a particular mindset. And if you're geared to churning out transactions, that ain't the mindset that's required. So I am it. And I'm not claiming that is some vast realm I have to myself. It's plenty big enough for me, but I don't have grand kind of megalomania. But it just so happens that, hey, this is my topic. And people do indeed like the book. I stumbled across a comment on LinkedIn a few days ago of someone I don't know in a comment not directed at me saying, Emmanuel South for contract drafting changed my life. So what the heck? People like it. So that is why I keep at it. So
yeah. So you mentioned first of all there that notably it's bigger than the previous version. So 70 pages, or even 72. I think I counted 72 pages. Anyway, 70 plus pages, bigger than the previous edition. So we've got more pages there. And something that I really like in this edition is that you refer quite often to your blog. So if there's like a post that you've written, you're linking it, which I think is really helpful for, anyone who's using the book, and also especially language learners, because if they're not sure about something, they can then go further in depth and check your website as well. So that's really, really helpful. Now, there are a few things that I particularly like. This was something that was present in the previous edition, which I think is really helpful for language learners, and it's your quick reference graph table on contract language. So you've got, the chapter on categories of contract language, but then this really helpful quick reference table. And for listeners who don't know what I'm talking about, Ken has systematically categorized the language to be used in contracts. For example, language of obligation, the kind of verb structures you want to use. And so this table, of course, there's a whole chapter going into detail about the type of language, but this quick reference table is quite helpful for language learners, I think, who want to see what the verb structure is, the type of language to use, and with examples there. So that's really helpful. Chapter 10, that's on references to time. Again, it was in the previous edition, but in this edition, there's some further examples given. And I've even referred to it today in my legal English teaching. And because I think that the thing that's helpful there is for students who are drafting contracts, and clearly, you're going to have to put references of time into a contract. They struggle sometimes with the prepositions, and you specifically mention prepositions in there, which I think is really, really helpful for people. And then also this very large chapter on your selected usages, where you talk through, a specific word and how it's being used correctly and incorrectly, and suggest ways to use it. So that vocabulary for legal English learners is really helpful. So we're going to talk through, some of the changes that Ken thinks is also really important. So, Ken, you mentioned that you've got a big change to the material/material adverse change chapter, chapter 9. So for listeners who don't know what we're talking about, Ken's going to explain. So the words material and material adverse change, it's much bigger than before, but there's more to it than that. So Ken, what are some of the key changes there?
In previous editions, I have alluded to the fact that the word material is ambiguous. But somehow in 4 editions, I didn't do a great job on it. And after publication of the 4th edition, the Delaware Chancery Court, I pay attention to what the Delaware Chancery Court says simply because it's the leading U.S. kind of business law court. It alluded to material adverse change expressing one level of importance, and the phrase in all material respects expressing a different, lesser level of importance. And that was the first time a court has stuck its toes in, or whatever phrase to express it, and dabbled in the notion of material being ambiguous. So it made this targeted little observation, which told me that was in effect just the entree I needed to do a more comprehensive analysis. Courts aren't in the business of doing that sort of scholarship. So I took that as my cue to revisit a subject that I spent enough time with but hadn't done properly. So the result was I wrote a law review article, a short law review article in the scheme of things, that'll be coming out this summer. And I put into the chapter of the 5th edition the essence of what is in that article. So I don't plan on getting into detail in this subject until the article comes out, simply because those who are keenest on this subject are going to be most interested in the footnotes and all that. But the essence of it is that the word material is vague. It's a function of circumstances. Okay, whether something is important enough to be material. It's like, okay, what is the context? Fine. We know vagueness. It's an inescapable part of contracts. But material is also ambiguous because there's case law that attributes different meanings to the word material in different contexts. And furthermore, contract logic, deal logic, will indicate that in different kinds of provisions, the word material is going to have different implications just because it's what makes sense in the context. So, material is ambiguous, with the 2 meanings being either non-trivial, just important enough not to be trivial for me to pay attention to it. That's one meaning. The other meaning is deal breaker. I've chosen that word just because it's accessible as a way of indicating, hey, this is sufficiently important that it puts in peril the whole point of doing the deal. I'm entirely confident in my analysis, and I've run this by luminaries who agree that I've shown that material is ambiguous. So why this is of interest is that it might be my most in-your-face analysis. I mean, I make a point of bucking the conventional wisdom when it needs to be bucked. And there are some topics that have been quite contrarian in that regard. My analysis of efforts provisions, for example, is at odds with what most people who work with contracts think the implications are. But my analysis of material might be most at odds just because material is a big deal thing. It's a kind of big law concept. People talk about materiality all the time. But the ambiguity is so fundamental an issue, and it has escaped everyone except moi and the Delaware Chancery Court, and making that little illusion in which they, in effect, acknowledged a reality before moving on. So I think this is going to be a little challenging for folk.
Mm-hmm.
So we'll see how it plays out. It might make things a little more difficult for people, because I think people have found it easier to deal with material when no one really knows what the heck it means, and that they confuse the ambiguity for vagueness, and they just shrug their shoulders and say, it's material. This is material. What are we going to do? What can we expect? And they are willing to deal with the confusion because they don't understand the sources of the confusion. I'm saying, well, in fact, let's distinguish between these two distinct meanings, and having those distinct meanings in mind is going to change how you approach negotiating. And it could well make things a little more complicated in terms of making the choices more, making them clearer. Mm-hmm. So are people going to pay attention to this? Who knows? I write for people who are interested in being informed consumers of this stuff. And once you're aware of the alternative meanings, okay, well, you're on surer footing, and you can do what you need to protect yourself a little better. If people just want to ignore that, then they'll keep winging it as they have thus far.
Mm-hmm. Good. So for listeners who completely have no idea of material, how it's kind of used, because of course you mentioned like it's ambiguous and it's vague and it is, but what I would usually say, it's quite often used as significant, or like a material breach, some significant breach that goes to the heart of the contract that then could lead to termination. But as you mentioned, like, what does that actually mean in practice? It's like deal specific. It's being interpreted in different ways. So for listeners, if you're interested in being more clearer, then I'd suggest getting a copy of Ken's book.
The simplest fix is, if you mean non-trivial, say non-trivial, because lawyers are generally wired to think of material being the deal breaker meaning. But if you mean anything that is beyond trivial, it's anything that is big enough that we're going to pay some attention to it, then use the word non-trivial.
Yeah, definitely. I think as well your term deal breaker is a lot more understandable, especially for non-native speakers, because they
I know, and
they get deal breaker.
Traditionalists are going to have a hard time with it. And my point is, look, traditionalists, you've foisted on us no end of hopeless jargon, legalistic, fusty words and phrases. So don't get all high and mighty about, deal breaker is too casual or whatever. It has the advantage of succinctly expressing the meaning in question. Am I going to expect to see a bunch of contracts using deal breakers suddenly show up? No. But if it helps people to understand the concept, the discussion in the book and the forthcoming article say, hey, if deal breaker is too much for you to cope with, well, then here's another way of capturing the same meaning. But it is the most immediately accessible meaning, which is why I was happy to use it.
It's a good word. So you mentioned this forthcoming article. Is it this article, the word material is ambiguous in contracts, why that's a problem and how to fix it, in the Scribes Journal of Legal Writing?
That is it. Yes.
That's it. Okay. Good.
People's pulses are quickening at the prospect, I'm sure. But hey, as with everything, I try to make what I write accessible. And it is often enough, it's complicated stuff, but you can express the complexity in a way that is not heinous to try and disentangle. So that's what I try to do, to make the complexity as accessible as it can be, taking into account the complexity. So that I do that with the law review article too. So, so with luck, if you have to wrangle these concepts in your work, you have to be able to understand them. So the odds are good that if you can understand the concepts at play, then you'll be able to understand my analysis of those concepts.
Do you know when this article's coming out?
This summer.
This summer. Ooh, okay, exciting.
That's all I got.
Well,
currently.
Hopefully soon. Okay, so we'll all be waiting on the edge of our seats for that exciting article. And just a point for listeners, Ken's mentioned contract language. It's difficult, it's complex. And an important point for listeners, because of course listeners to this show are usually international lawyers whose first language is not English. And so what often I get, like my students often say to me is like, I don't understand these contracts because it's my English, whereas Ken's writing is not necessarily geared towards non-native speakers, or it is, but as well it's also aimed at native speakers, because native speakers are also doing this exact same stuff of writing with completely incomprehensible language, and they're not even able to understand it themselves. So I just sort of wanted to point that out to listeners that
generally
even if
the key issue is not that you're not a native English speaker. The key issue is that traditional mainstream contract language has become dysfunctional, or perhaps always was dysfunctional, as a function of generation after generation of copy and pasting, and a legalistic mindset that just relishes bogus complexity. So I've actually found non-native English speakers can be more adept at basics of how English works as they've had occasion to study it. Yeah. So if you're able to work with contracts, if you're equipped to handle contracts at all, you'll be equipped to handle understanding contract language. I mean, that's a rather circular sort of logic, perhaps. But I simply mean that there's a basic level of command of English that is required, but you can take into account when you're thinking, do I have that command of English, that no one has command of traditional dysfunctional legal contract prose. So if you're able to handle English generally but have trouble with contracts, that's the problem. Is contracts. The problem isn't your understanding.
Yeah, that's a good way to put it. All right, so moving on, let's move on to the selected usages chapter. So chapter 13, where basically I've done my calculations, and in the new book, there's 152 pages of selected usages, whereas in the previous edition, it was 136. So it's bigger. We've got extra pages, and we've got extra selected usages such as appurtenant, coterminous, deliver by hand, derogate, and vest, which were not in the previous. All very fascinating terms here. And, that's just a few, to name just a few. But there are some very important ones that I think you can speak about. The first one was consequential damages.
Okay. Now, I'm keenly aware that listeners are not going to have endless hours to listen to this podcast. So I will try and cut to the chase. Consequential damages. Yes, in 4 previous editions, I did not do a good job. For whatever reason, I just took that subject more seriously this time around and ended up speaking with people who've written about consequential damages, and I'm pleased with how it worked out. I just never understood the whole idea of excluding consequential damages. What the heck is going on? Well, turns out that what's going on is that there are 3 possible meanings that people have in mind. Consequential damages, one meaning is that it's a function of special circumstances. Consequential damages are what you get if you are entitled to damages relating to special circumstances that you told the seller about. And so they become part of the deal. The code phrase for this is the second branch of Hadley v. Baxendale. I studiously avoided embracing that jargon, but I finally had to succumb for this analysis. So special circumstances is at the root of one meaning. Another meaning, which is in fact in Black's Law Dictionary and not the special circumstances one, is a function of causation. We'll leave it at that. The third meaning is what it appears plenty of people think they are excluding by excluding consequential damages. They have in mind remote damages, stuff that just could not have been foreseeable in any way when the deal was struck. Well, guess what? You're not entitled to remote damages anyway, so there's no point excluding them. So 3 possible meanings, hence confusion. And I propose instead, hey, the special circumstances meaning is the one that makes most sense. Well, at least if that's what you have in mind, then don't use consequential damages. Say we're excluding consequential damages. Instead, address special circumstances directly and say whatever is on your mind in terms of whether there are special circumstances at all and what the implications are. So I propose in the book a couple of sentences that just deals with that directly. So the question for anyone who excludes consequential damages is, first of all, what do you have in mind? And for 93% of people, I suspect the answer is, well, nothing, because it's all impenetrable stuff. So I'm just excluding stuff just because everyone does anyway. So, okay, so the idea is, all right, well, these are the possible meanings. And generally the most deal relevant ones would seem to be special circumstances. All right, well, consider this language. Is this relevant? Is this stuff you're concerned about? If it is, then you might want to include this language in your deal instead of just kind of waving your arms around and throwing in consequential damages in the hope that somehow it does something relevant. So I think that constitutes progress for me in terms of actually getting down to saying something helpful for purposes of a phrase that is just, for pretty much everyone, is just mysterious. So there's that. Another phrase that I mentioned, word that I mentioned to you is including. I'm not going to get into the details of including, but I just mention it because it was fun. Because including ends up being something of a messed up story, just in terms of possible meanings that people have in mind when they use including. So it's kind of all over the place. Ideally, don't use including at all. And I found a way to include in the discussion something that I described, I forget what word I used, but the best part of the fifth edition was my including the what was said in a 1980s, I think, Nike commercial involving
Let's see if I
Charles
can find it.
Barkley, NBA player, and Humpty Hump, rapper.
Oh,
And Humpty Hump used a phrase,
what a name!
used including including in a way that was very distinctive. So one of my readers told me about this, one of my deranged readers, and I had to include it.
Okay, so for those of you who are going to get the book, that the reference that Ken was making there was at point 13.396.
Yeah, check
page
it out.
420. Check it out.
It is just another example of this stuff being complicated. I just have spent my years just untangling this stuff and trying to make it accessible, but it is always going to be complicated.
And I think just for listeners, don't be disheartened with your language in terms of it's complex, right? This is complex, high level stuff, and contract drafting language is complex, but Ken's writing can certainly help you understand it and also write more clearly. I just wanted to mention a point regarding consequential damages, just for listeners who are completely like, what are you talking about? So of course, consequential damages, it's one of those words that's often used in limitation of liability clauses, where you throw in a load of stuff that you're trying to exclude, and you're trying to exclude basically liability for any kind of damages. And Ken nicely links to an article that he's written on his blog, which was called Limitation of Liability Overkill, where you did some kind of like search and found that there are, lots and lots of different types of damages or loss that are used, and there's different wording like special damages, direct damages, general damages, indirect damages, incidental damages, punitive damages, exemplary damages, etc., etc. I don't think I can list them all. But anyway, it's sort of students sometimes come across, or, lawyers are coming across these clauses, these limitation of liability clauses, where everything's thrown in, nothing makes any sense. And so Ken's taken one of the most common ones that appears, which is consequential damages, analyzed it, and looked at what the potential meanings are and what you can do instead of using it. And so that's good. And the including, the use of including, it's used in many different ways, like trying to introduce an exhaustive list, trying to include things in lists. And as Ken said, it can create problems. So I think Ken analyzes it very well there and has lots of examples of the way that it's used and what you can do about it. So then I want to move on to ask you, so, we've talked about that you're like really the only person that's doing this. Why is that the case, Ken? Why?
I know we touched on that briefly with the last time we spoke. I think it's a function of, first, my just being hardwired to want to do this sort of thing, to create a semblance of order out of chaos. And in terms of why no one else, I think people are just too busy getting by. Figuring this stuff out has required of me just so much work that it would be inconsistent with a regular legal job. Whether you're at a law firm, whether you're in academia, wherever the heck you are, it's not going to reward the sort of effort I have had to put in. So I did it just hardly on a whim. I just did it because I had the urge, and I figured someone had to do it. And with luck, if I'm the only person, maybe I'll make a livelihood out of it. Through some miracle, it pretty much worked out that way. But I can understand why no one else has been inclined to do that. And as my work has become more comprehensive, I think that has been a disincentive for others, because they'll just say, hey, what if I want to challenge Adams, I'm going to have to kind of recreate his work and then go beyond it. That for most people, that would not be a worthwhile use of their time, because I've had 20 years to refine my analysis, so I am comfortable with it. And particularly after having fixed glaring holes like consequential damages, it would not be a rewarding use of people's time to just recreate my work. And so yes, the more I have done, the less others have been inclined to join in, which just makes it weird. The only people I really encounter are people who are just on social media, just kind of talking randomly. And I've given up policing that turf. It's a losing proposition. I think I've created a barrier to later entrants. So I don't see anyone else coming along. I used to think that this sort of thing was something of a rarity in terms of just kind of one person owning a particular discipline, but I've encountered other examples. But I used to think that the default mode in the world was competence. Stuff will get done somehow. People will pay attention. I think recent years have shown us that is not the case. So I think that there are all sorts of realms where we just owe it to one person who has cared enough to do what's required. Mm-hmm. So I think that ends up being the case a lot of the time.
Now, you mentioned as well that you've got a bit tired of engaging in conversations on social media where, you're just like correcting people on things, and that you're sort of slightly going in a different direction now. So you've written the 5th edition. You've also been offering training. So the training for listeners, Ken offers a couple of types of training. The one that's relevant for you if you're a language learner is that he offers contract language training, online training, where he's talking you through the language of contracts and helping you understand. Do you want to explain a bit more about it, Ken? How's it going?
Sure. Up to 2020, I was endlessly traveling the world doing in-person presentations. That, of course, ground to a halt. I did my first in-person presentation since March 2020. I did the first one. That was the last one until a couple of weeks ago when I went to Philadelphia, did an hour and a half at a law firm, and was reminded of how tiring it can be in terms of the travel, in terms of being on your feet and so on. But anyway, I think going forward, in person is going to be a rarity, just because that's the way the world is going. So I have my online presentation. I've been doing masterclass for 3 years, 8 weekly hour-long sessions with a course curriculum and materials and quizzes and reading that you do to prepare for each session. And I just announced a few weeks ago my first online public presentations, 2 3-hour sessions on consecutive days, where it's essentially me just going over stuff that I think people who are new to the book would find helpful. So it gives people a choice based on how much upfront effort they want to do. presentations will give you my sense of what you find helpful to help you get into the complexity. Whereas masterclass gives you an excuse to just become even more familiar in terms of taking quizzes and doing reading, and we discuss particular kinds of contracts that have issues built in and highlighted, and I say, how do we fix that? And we talk about it, and then I give them my annotated version. So it's a more curated sort of, dare I use that word, experience. But ultimately, it's the book that is the foundation. The idea is if you get command of the book, then you will have what it takes to be an informed consumer of contract language. But there's enough complexity that I can understand people wanting to be guided a little. So those are the two options.
What kind of students, participants are you getting?
American and Canadian, and then international contingent, certainly. In the public sessions of Masterclass, I'll generally have a scattering of people from places other than the US and Canada. I also have organizations that have hired me to do one or more series of masterclass for their people. And there have been companies from Europe and Asia that have asked me to do that, and the Middle East that have asked me to do that.
Good. So for listeners, if they're considering it and they're worried, like, oh, is this for international people? Then yes, the answer is yes, certainly. Ken, tell me, what is down the line? Potentially
peace and harmony and rationality. Well, I will have perhaps other training modules down the line, on-demand training, where you don't have to suffer through me live in your face, but instead a recording or some such. But all that is a gleam in my eye. I have more immediate challenges at the moment. When we last spoke, I said that the only fix, really, the only way to scale up quality contract language is to give people an alternative to the copy and paste machine. Because if our only source of contract language is rummaging in contracts that have been used for other deals, then we're just always going to be presented with stuff that is, to some extent, less clear than we would like it to be, and less relevant than we would like it to be. So the idea is, instead of endlessly copying and pasting on faith, it would be good to have an alternative, and the only alternative there could be is a questionnaire-driven system that allows you to go through and answer questions regarding what deal points apply, and you consult annotations that explain the choices being offered. And when you've completed the questionnaire, the system pulls together and adjusts appropriately the preloaded language that has been compiled by subject matter experts under editorial control, using language that complies with my guidelines. So you end up getting something that is reliable and clear in a fraction of the time that it would take you to create that, on the understanding that even if you do create it, it isn't going to be anywhere near as good because most people just don't have access to the expertise and don't have the time and inclination to do that sort of heavy lifting. So that has long been my dream. That is what I've wanted to do for the past 15 years. I've been knocking on doors and I've had no takers until recently. So in effect, the transactional world has made zero progress in terms of alternatives to copying and pasting. There are a couple of vendors and some trade groups that have templates, but they ain't great. So I've long wanted to do that sort of thing, and have thought that if I don't, then my work will remain a bit of a vanity project in terms of it being of use to people who have the stomach to handle this sort of complexity. But that's a minority of people who work with contracts, a tiny minority. Most people just don't want to be told, hey, here are some quality materials you can use to build your own contracts. Most people are going to say, I don't want to build contracts, thanks. I do deals. I want to do deals. I don't want to build contracts. So I am now in discussions regarding this creating this sort of initiative. It's early days, and it's a desperately old-fashioned project. It's a publishing project. It's not a tech project. So it just requires expertise and people writing stuff with a technology print, a kind of a fancy printing press of the sort that is not glam software or anything. It's just the sort of document assembly technology that's been lurking around for 15 years. So we'll see. But that is where I wish to devote my time going forward. Because with the 5th edition, we're pretty much there. Hey, there'll be a 6th edition, I'm sure, in 8 years or whatever the heck it is. But we have more than enough to know what we need to put together clear contract language. Now, what's required is actually doing the work. So
yeah, I think that's a great point in terms of that this book, it's incredibly helpful. It's a really helpful resource. I think that anyone who works with contracts should have it on their bookcase and should refer to it. You can just open it anywhere and you'll find something interesting to read, basically. But at the same time, a lot of people are very busy. They don't want to put the effort in. And so and I remember the last time we spoke, you mentioned, I asked you something like, what's the contract drafting utopia? And you mentioned this sort of dream of yours to put together some kind of, system where people can sort of click through and they've got this contract that's based on your principles. And so I'm glad to hear that you're in discussions, that something's moving there. So it sounds another exciting thing that we can look forward to. Regarding training, you're also interested in potentially running training for teachers. So teachers to teach your stuff.
Yes, that is something I put out there just on a whim a week or so ago. The idea being that anyone who has the book will have access to what I know. I mean, Ken Adams, is not an essential component in the mix. Anyone can read the book and use it. It follows anyone can teach what is in the book. But people might find it helpful to get training from me in that regard, and I can make available my materials. So that was just my way of saying, hey, if anyone wants to present a series of masterclass to people in their organization, I can help you do that. And I'm all for it. That's a broader idea that, for example, at some point, I would like to create a law school and business school course for teaching contract drafting, essentially working with contract language. And I have in mind creating a set of online materials with assignments, et cetera, et cetera, et cetera, and making it available to schools so that faculty can teach that without having to dream up an entire curriculum themselves. So, for example, adjunct faculty say, okay, you want to teach contract drafting? All right, well, teach this. And here are all the materials, and you'll have enough discretion that you can throw in your own war stories or whatever the heck you want. But it makes things easier for those teaching, and it makes things more dependable for the schools in terms of knowing what they're getting into. But that's sort of lower down the list of stuff I need to do. A starting point for that, the kind of condition to that sort of initiative going forward, is my getting started on my library of automated templates, because I don't want to teach contract drafting to people who are just going to have to do copy and paste to do assignments or anything. I want the foundation to be, here is the system that will give you quality contract language. And now we want to just help you understand the basis for building that system and how you can access the system and then revise stuff as necessary. So rather than building on a foundation of, hey, let's copy and paste on faith, whatever stuff of unknown quality we happen to stumble upon, instead provide a decent foundation. So first comes the foundation and then various projects that can build on it.
Well, I think certainly listeners will be interested in the potential, I don't know quite what to call it, but, the template system.
Library of automated templates will do.
Library of automated templates. They'll certainly be interested in that. And certainly there's a lot of listeners to the show who are teachers who teach, legal English or law across universities around the world. And so they would probably be interested in that potential training as well. Mm-hmm. So you shared with me a blog post about that, and I'll leave a link to it in the show notes. And I guess that people can get in touch with you if they are interested in that. You mentioned, so, in our email before, as we were arranging our interview, that artificial intelligence isn't going to fix contracts. I've spoken to your friend Alex Hamilton about this before. I think he's certainly on the same page as you.
It is impossible to avoid people sharing their views on artificial intelligence. And I am not going to do that generally, because I don't need to add my semi-informed voice to the cacophony. Instead, I'll limit myself to just saying that artificial intelligence will never fix contracts as things stand, because artificial intelligence has to be trained on something. And all there is to train artificial intelligence on currently is dysfunction of various sorts. So the result will be that if whatever you train the artificial intelligence on can't be relied on, because it's just mainstream contract drafting. And so it'll just feed that to you in return, and you're not going to be able to rely on it. Well, in addition to the inherent unreliability, it'll also present you in a contract its notion of okay, what kind of provisions to fill, what deal points to include. And if you want something more guided, you're going to have to start putting in a bunch of prompts talking about what deal points you want. If you have the expertise to do that, you don't need artificial intelligence to collate the stuff for you. So all around, it is not a viable prospect. And I did a blog post a week or two ago saying that document assembly technology software is is a far better way of making relevant contracts accessible compared with just winging it and asking artificial intelligence to give you stuff. So yeah, something desperately old-fashioned like document assembly software is far better suited to making that sort of tailored deal points available to you in a coherent manner. So that ties back into my notion of the automated library of templates. So yes, I think the chatter about artificial intelligence is going to keep on going, but contracts is kind of is exempt from that because there's nothing decent to train the artificial intelligence on. So that gives me a certain freedom in terms of just saying, I don't have to think about it because it ain't going to be able to present me anything decent. The legal profession has long looked to some way of saving the legal profession from itself. And it tends to throw money at whatever buzz phrase comes along. And AI has been the mother of all buzz phrases. And so we're kind of shifting from copy and paste to artificial intelligence as a way of surrendering control and responsibility. And say, hey, let some other system do the work for us and save us from ourselves. So yeah, kind of depressing. But as I said, I don't even have to, just kind of rail against artificial intelligence for contracts because it's not even remotely in contention. A commentator, blogger, Casey Flaherty, in a lengthy post on AI, said something to the effect that, hey, when the 6th edition of Emmanuel Sal for contract language comes around, perhaps we can just feed that to the artificial intelligence and Bob's your uncle. You'll be able to refine a contract so that it complies with MSCD. I think that any system that tries that will start emitting blue smoke because it's just changing traditional contract language to my stuff involves a whole lot of surgery that I don't think it's realistic. The far easier thing is just, hey, let's clear the decks. Let's present people with some fresh air into the system rather than having the starting point always be the dysfunction. Yeah. So.
I mean, you are very much, on the same page as what Alex Hamilton said.
I'm always following in Alex's footsteps. Darn it! He always beats me to it.
And also, so I think I've mentioned to listeners like the limitations of ChatGPT because of course it can be helpful in some respects in language learning, but it also has incredible limitations and you've got to be really, really careful with it. And certainly listeners, don't use ChatGPT to write your contracts, would certainly be the message. Get a copy of Ken's book, read it, and work.
Casey Flaherty, in that post I mentioned, quotes me to the effect that if you're doing the copy and paste thing, you have no basis for being snooty about artificial intelligence, since they're just two versions of the same sort of thing, which is just entrusting to randomness the task of creating your contract. So there you go.
Good. All right. Okay. So I think we've come to the end of my question list. So hopefully for listeners, they now have a good understanding of some of the changes contained in this fantastic book here. So, go and get yourself a copy. I'll leave all of the links in the show notes. If you want to contact Ken, what's the best way to contact you, Ken?
Hey, kadams@adamsdrafting.com will do just fine.
Excellent. Okay, so you can drop Ken an email. You can find Ken on LinkedIn, Ken Adams. So great. All right. So thank you very much, Ken. That's a real pleasure to have you back on the show. And thank you. Thank you.
No, hey, my pleasure. See you in 3 years or some such, perhaps.
Okay. So thanks for listening. Bye.